to adopt more stringent air quality standards than the federal standards in place without receiving pre-clearance from the United States government?
Senator, this is not an area that I work in, I suppose, but this is not an area that I work in.
Yeah, what about areas that are protected by the Bill of Rights? Let's suppose that a state wants to pass laws dealing with COVID-19 that might have the impact of restricting religious freedom by, for example, restricting the number of people who may congregate in a church or otherwise. Should laws like that have to first receive pre-clearance before they can be enacted by a state?
Well, Senator, I'm here to talk about the right to vote, which falls to the 14th and 15th Amendments, and Congress has broad powers to enforce.
And I assume you'd also agree that through the 14th Amendment, Congress also has broad powers to protect other fundamental individual rights, including religious freedom. What about the Second Amendment? What about gun laws? Should a state be required to receive pre-clearance from federal officials before adopting gun restrictions?
This is not an area that I work in the Civil Rights Division, but I do know that the right to vote is unique, it's special, and it's something that the Supreme Court has routinely said that Congress has broad enforcement powers under the 14th and 15th Amendments to protect.
Sure, and those broad powers also extend to other rights that people have. Now, I think that it's important for us to remember that our nation is built on this principle of respect for the sovereign entities that our states are, and for the ability of each sovereign state, for the people, through their elected representatives, to be able to adopt laws that they deem fit. Because, of course, the sovereigns in our republic are, in fact, the people. The people have yielded some of their sovereignty up to the states. In other areas, they've yielded it to the federal sovereign. The Supreme Court of the United States has made this very clear in a number of cases over the years, including the Supreme Court ruling in the Shelby County case, in which the Supreme Court of the United States said, quote, "The federal government does not have a general right to review and veto state enactments before they go into effect." In fact, the Founding Fathers considered and expressly, decidedly rejected giving the federal government the power to provide what they refer to as a negative or a veto over any and all state laws. So we don't advocate for pre-clearance, even in areas surrounding our constitutional rights and the constitutional rights belonging to individuals. You know, if the laws passed by a state happen to violate the Constitution, we do, of course, have a procedure in place for challenging those. They go to the federal judiciary. The parties can litigate those. After, of course, the constitutional arguments are made to the legislative body considering them. If they fail there, they can raise them with the judiciary after they become law. And so we've got to be very careful that we don't neglect this principle of federalism in our lawmaking processes. And we can't do this here. We can't sacrifice this principle even for rights that we consider important, because the sovereignty of the people is also important. But there again, if the states do something unconstitutional, their enactments can be deemed unconstitutional, and the enforcement of those laws and their implementation can be enjoined. Unfortunately, we've had a number of politicians, including some progressives, who aren't satisfied with merely dictating voting procedures to the states. In fact, then Senator Kamala Harris in 2019 proposed using pre-clearance to usurp state control over regulations involving health, safety, and welfare situations arising in the context of abortion. Ms. Clarke, when I hear from you, your remarks and your testimony, and one of the things that I hear from you is that the average American's concern about the integrity of our elections is somehow based in racism. Fortunately, the facts don't support that premise. Now, progressives have tried to label any integrity election protection procedure, such as the laws that have been passed, for example, in Georgia of late, as somehow amounting to racist voter suppression. And yet, these provisions have strong support from voters across the political spectrum, including among minority voters. So can you tell me, Ms. Clarke, what exactly is racist about requiring a person to provide a voter ID when participating in the precious, sacred, constitutionally protected process of voting?
Thank you, Senator. So the inquiry is whether or not a particular law is discriminatory, and we won't know that until we actually look at the facts. We look at the particular law at issue, and we look at where is it being applied, and are there racial disparities in terms of who has access, to example, to the limited forms of ID that might be called for by a law. So I think the inquiry is about discriminatory effect and discriminatory purpose.
And I would note that the senator's gone considerably over his time. I didn't want to interrupt him, but I was turning to Senator Klobuchar, and I do that because we're having both